Welcome to the deep dive. So, for nearly 100 episodes now, we've been digging into the political and legal worlds of classical antiquity.
It's been quite a journey.
It really has. And now we're sort of bringing it all together for one big comparison. Athens and Rome, their legal systems. These are the absolute pillars of the Western legal tradition.
Absolutely. Twin pillars.
Yeah.
And today, our mission, if you like, is to really dive deep one last time, comparing their strengths, their weaknesses, and just how differently they approach the whole idea of justice.
It's fascinating because they really do feel like mirrors of their societies.
They absolutely are. You can say these systems reflect the political soul of each city. Athens is all about that participatory buzz, the democracy in action.
Yeah, very hands-on.
Very. Whereas Rome is about structure, system, professionalism. It's almost the opposite vibe in many ways.
So we'll be looking at how Athens relied so heavily on rhetoric, persuasion, these big citizen juries.
Amateur justice, really.
Right. And contrasting that with Rome's focus on, legal science, the expert jurists, this whole professional class developing the law.
It's that Athenian passion and direct involvement versus Roman hierarchy and legal abstraction. We'll trace how each system grew, how it actually worked day to day, and the legacy they've left behind.
And our sources really let us get into the nitty-gritty, don't they? Beyond just the textbook headlines.
Oh, definitely. We can compare the assembly's power versus the detailed work of the Roman jurists, the responsa prudentum.
So if you want to understand that tension we still see today between, let's say, democratic ideals in law and the reality of expert-driven systems, this comparison is kind of essential.
It really is foundational.
Okay, let's dive in. Section 1, Justice and the Political Foundations. Where do we start with Athens? It has to be the democracy, right?
Absolutely. You can't understand Athenian law without understanding the rise of the demos. And the big starting point, really, is Solon's reforms, back in the early 6th century BC.
And these weren't just minor tweaks.
Oh no, they were fundamental. Solon gave the ordinary citizens, the masses, a real foothold, a locus standi, against the old aristocracy. He created these new bodies.
Like the Heliaea, the big court.
Exactly, the Heliaea, the council, and crucially, he made magistrates accountable after their term. That was huge. It put a check on unchecked power.
So it was a power shift, legally encoded.
Precisely. And once Solon laid that groundwork, then came Cleisthenes, and the demos became, as the sources say, paramount and sovereign.
And that sovereignty wasn't just symbolic. It flowed directly into these popular courts, the dicasteries.
Yes, these massive citizen juries. We're talking hundreds, sometimes thousands, of citizens sitting in judgment. They weren't just voting in the assembly, they were doing justice.
Which must have radically changed the role of the old magistrates.
It did. They became secondary. Their roles were reduced to, almost administrative functions in the judicial process. The real power, the final decision, lay with the citizens. It was seen as this eminently democratical setup. Justice and politics were completely intertwined.
Okay, so the people are in charge. What about the substance of the law? Let's take homicide. Draco's laws were famously harsh, but Solon kept the homicide laws. Why those specific ones?
That's a great question. They survived, it seems, because homicide wasn't just seen as a crime against a person like we might think of it. It was deeply tied up with religion, with pollution, miasma, and with philia, that whole complex of kinship, duty, loyalty.
So killing someone polluted the whole community.
Yes, and it was the family's duty to pursue justice, to cleanse that pollution. The law imagined the victim's kin acting as one unit in the dikiphono, the private prosecution for murder. Restoring cosmic and social order was the goal.
But the reality, I imagine, wasn't always that neat family unit seeking justice together.
Far from it. The sources give us some fascinating glimpses into the messiness. There's this famous case against the stepmother. A stepson prosecutes his stepmother for murdering his father. Okay, seems straightforward enough under the dikiphono idea.
Bloody.
The stepmother is defended in court by her own sons, the victim's other children, the prosecutor's half-brothers.
Wow. So much for a united front.
Exactly. It shows how internal family dynamics, maybe greed, rivalries, different loyalties, could completely shatter that legal ideal. The court had to navigate these incredibly personal, contradictory situations.
Beyond homicide, the Athenians were also really concerned with hubris. We hear that word a lot, usually meaning arrogance. What did it mean legally?
Legally, hubris was a serious charge. It wasn't just being arrogant. The sources show it mainly referred to things like physical assault against free citizens or serious sexual violence and aggression.
So it's about violence, but with a specific flavor.
Yes, the flavor was contemptuous power, acting in a way that deliberately humiliated or dominated another citizen, infringing on their status and dignity as an equal member of the polis. The law against hubris was a tool to protect that civic equality.
Okay, fascinating. Now let's pivot. Across the sea to Rome, if Athens starts with the democratic collective, where does Rome start?
Rome starts small. It starts really in the isolated household, under the thumb of the paterfamilias, the head of the family. Early Roman law, these themistes, they weren't public decrees initially. They were more like the absolute commands of the patriarch to his wife, kids, slaves.
That sounds incredibly hierarchical and private.
It was. Early Roman jurisprudence was very limited in scope. Laws didn't really bind individuals directly in the early days. They bound families. And the patriarch was the legislator within that family unit. Public law initially just sort of ratified this domestic power.
A total contrast to the Athenian public square. And religion played a different role too, right? Reinforcing this hierarchy.
Absolutely. The Roman home was almost a sacred space, a temple in miniature. Daily life involved rites tending the hearth fire, honoring the household gods, penates, revering ancestors. This deep hereditary religious structure provided the justification, the title, for the early aristocracy's dominance.
So religion bolstered the elite, whereas in Athens the move was more towards secular democratic participation.
Exactly. In Rome, religion and hierarchy went hand in hand from the beginning.
So if it starts so family-centric and hierarchical, how do they even get to the idea of a state, a res publica, a commonwealth?
Well, the sources, like Cicero, point to a very practical driver: protecting private property. The idea was that people formed communities, commonwealths, mainly for the security needed to keep what was theirs.
Property defense is the glue.
Pretty much. It's a foundation built on the hope of security for one's possessions, which is, again, a different emphasis from the Athenian focus on civic, virtue, participation, and the pursuit of equality as the basis for the state.
Okay, so two very different starting points. Athens, democratic aspiration, equality. Rome, patriarchal power, property defense. Let's move into how they actually resolved conflicts. Section 2, personnel and procedures. Back to Athens first.
Right. So you have these big democratic courts, but how did they function? Well, one interesting aspect is that a lot of the litigation, even within this formal system, was still seen and described as a kind of feuding behavior.
Hold on, isn't the point of courts to stop feuds?
That's the modern assumption, yes. But in Athens, it seems the courts sometimes just became another, perhaps more formalized venue for the feud. It didn't necessarily replace it, it channeled it.
And given the massive untrained juries, how did you win your case, your feud?
Persuasion. Rhetoric was absolute supreme. You won by appealing to the jury's emotions, their political biases, their sense of shared identity. It wasn't about dry legal arguments, primarily.
And the skilled speakers, the orators, they knew this.
Oh, they were masters. Look at Lysias in his speech against Ageratus. He basically tells the jury again and again, you are all Democrats. This man worked with the oligarchs who hurt us. He's framing it entirely in political terms, using the shared trauma of the 30 tyrants.
So he's playing on their identity and emotions, not just legal points.
Exactly. He's substituting the certainty of hindsight, we know these guys were bad, for the uncertainty of the original situation. It's pure rhetorical strategy aimed at that massive, sympathetic, democratic audience.
So the trial itself becomes this big performance.
A performance, absolutely. And even before the main trial, you had these public arbitration hearings, often informal, held outdoors, attracting crowds.
Especially if something dramatic was happening.
Like, say, the torture of a slave for testimony, which, remember, was a permitted legal procedure then. That would draw a crowd.
Sounds chaotic.
It could be. Sources mention cross-examinations, consultations with family and friends right there, but also total disorganization. Hearings running past midnight because people wouldn't submit documents. One guy even complained that a key piece of evidence, an inscribed tablet, was actually stolen during the oath-taking part of the hearing.
Stolen from the hearing itself.
Right in the middle of it. It shows you the energy, yes, but also the potential for chaos and lack of strict procedural control.
Okay, that paints a picture. Now, Rome. If Athens was about democratic energy, maybe bordering on chaos, how did Rome build its system? Presumably aiming for the opposite.
Pretty much. Rome went for professionalization. The absolute core of Roman legal development wasn't the impassioned speech to a huge jury. It was the considered opinions of legal experts, the responsa prudentum, the answers of the learned.
The jurists, this is where Roman law really takes off, isn't it?
This is its defining feature and its enduring legacy, especially for civil law systems. These jurists weren't technically legislators, but their interpretations carried immense weight.
How does that work? How could they change the law by sort of not changing it? You mentioned fictions earlier.
Right. They would write these detailed commentaries, glosses, on existing laws, starting with the 12 tables. Through interpretation, they could massively extend the law's scope, narrow it, even effectively overrule parts of it. But, and this is key, they did it while maintaining the fiction that the original sacred text remained untouched.
So it looks like continuity, but it's actually constant adaptation.
Exactly. It's reform disguised as interpretation. It preserved the legitimacy of the ancient laws while allowing for practical evolution. Very clever. They're very Roman.
And this professional approach became even more crucial as Rome shifted from republic to empire.
Right.
You needed experts to run that huge machine.
You absolutely did. It required a massive professional bureaucracy. Interestingly, early on, the emperor often used his own highly skilled slaves and freedmen to run things a sort of patrimonial bureaucracy.
Because they had the technical skills.
Yes, literacy, numeracy, administration. But over time, especially by the end of the 1st century AD, the heads of these bureaus were increasingly equestrians, the knight class. This signals a shift towards requiring a long career path, specialized training, real professional expertise to manage the empire's legal and administrative affairs.
So a stark contrast to the Athenian citizen judge rotating in and out.
Night and day. And the Roman judge, particularly later under the empire's cognitio procedure, wasn't just a referee. They had real power.
What kind of power?
They had liberum arbitrium statuendi discretion in sentencing, especially when the law didn't specify an exact penalty. They were expected to weigh the facts, apply legal principles, and make reasoned judgments.
But was that discretion applied equally? Or did Roman social hierarchy creep in?
Oh, it more than crept in. It was often explicit.
Yeah.
The sources are very clear about this. Take plunderers, exploiters. If no specific penalty was set, a judge had discretion. They might sentence a lower-class defendant, yours, to hard labor in the mines. But an upper-class defendant, honestiores, senators, equestrians, for the same crime. Maybe they'd just lose some status or be exiled temporarily. The law might be universal in theory, but the punishment was deeply stratified by social class.
So professional system, but still deeply reflecting the social structure. Let's dig into the underlying philosophies. Section 3, legal philosophy and methodology. Athens first. How did they think about justice conceptually? Drama seems key here, like the Oresteia.
Yes, Greek tragedy is a fantastic window into their thinking. The trial scene at the end of the Oresteia in the Humanities is crucial. It stages the founding of the homicide court on the Areopagus.
And what does that trial show us about their concept of justice?
It suggests justice is complex, maybe even ambiguous. It's about signing responsibility, sure, but the outcome isn't simple. It involves gods Apollo defending Orestes, Athena presiding, and humans, the Athenian jury. Responsibility seems shared, diffused.
And the Furies, the old goddesses of vengeance, their role is complicated too.
Very. They start as agents of Zeus's justice, demanding blood for blood, but then they're pitted against Apollo, who also represents Zeus. It highlights this tension between ancient blood guilt traditions and the need for civic order in the polis. Justice has to somehow accommodate both vengeance and reconciliation. It's a negotiation.
And the way truth emerges seems slippery, relying on interpretation, even deception.
That's a really interesting point. Think about Clytemnestra's moment of realization. She understands her doom not from a clear pronouncement, but from a servant's ambiguous, riddling phrase, the dead are killing the living, or maybe the living kill the dead.
A riddle reveals the truth.
Yes, and she grasps the deadly logic, saying, "We are being destroyed by deception, Deloius, just as we killed." It underscores how much Athenian justice relied on interpreting signs, on rhetoric, on finding truth hidden within ambiguity.
But this reliance on interpretation, on the assembly's mood, made the system vulnerable, didn't it? Politics could easily trump law.
Absolutely. The assembly often had the final say in major cases or policy decisions with legal implications. Political expediency could, and often did, win out.
Any examples jump out?
Well, there's the incident with the Peloponnesian ships. Athens refused to return 60 ships after a truce ended, using a really flimsy excuse, a slight infraction by the other side. It was clearly about maintaining a military advantage, using a legal pretext for political gain.
So the letter of the law could be bent for political reasons.
Definitely. Or think about Cleon, arguing against peace with Sparta. The Spartans offered terms, but Cleon, driven by his own political ambitions and wanting to continue the war, convinced the assembly to demand impossible conditions. The goal wasn't a just resolution. It was a political maneuver within a quasi-judicial setting.
That constant risk of political override seems like a defining feature, maybe a weakness.
It's certainly a defining feature. Whether it's a weakness depends on your perspective. But it definitely contrasts with the Roman attempt at systematic stability.
Okay, let's talk about Roman abstraction then. Fictions and natural law. You mentioned fictions as a conservative tool. Can you unpack that a bit more? How is making something up conservative?
It sounds counterintuitive, I know. But the jurists use fictions precisely to avoid openly challenging or changing venerated old laws like the 12 Tables. By pretending a situation met the old requirements, they could extend the law's reach or adapt it to new circumstances without admitting the original law was outdated or flawed.
It preserves the authority of the past while allowing change.
Exactly. It maintains that all-important continuity and legitimacy.
Can you give us that classic example again? The citizenship fiction?
Sure, the fictio civitatis. Roman civil law, the cremia civil, strictly speaking, only applied to Roman citizens. Big problem as Rome expanded and dealt with non-citizens, Peregrini. So what did they do? Instead of rewriting the whole code, the praetor, guided by jurists, would instruct the judge in certain cases to perceive as if the foreigner were a citizen for the purpose of that specific legal action.
So the fiction bridges the gap.
Precisely. It allows the existing legal framework to function in new contexts without fundamental upheaval. Adaptation through artifice.
Now, besides fictions, they also developed concepts like ius gentium, the law of nations, and aequus natural law. How did those relate?
They were closely linked, often identified for practical purposes. Ius gentium was seen as the set of customs and rules recognized by all peoples, principles evident through common sense or natural reason.
So, kind of like universal common law based on reason.
In a way, yes. But this identification created philosophical tension, most notably with slavery.
Because slavery was everywhere, part of the ius gentium by definition.
Exactly. It was a universal practice. But for Roman jurists influenced by Stoic philosophy, ius naturalis suggested all humans are fundamentally equal and free by nature. Slavery clearly contradicted natural law.
So they had a clash between universal practice and philosophical ideals.
A major one.
Yeah.
They had to acknowledge that the ius gentium, what everyone does, didn't always align with the ius naturalis, what pure reason dictates. It shows the limits of their attempt to ground law purely in rational universal principles when faced with entrenched social realities.
But this systematic approach did lead to incredibly detailed laws in specific areas, right? Far beyond Athens.
Oh, absolutely. Take inheritance law. The Romans developed meticulous rules. Estates were formally divided into 12 shares, unciae. They had complex calculations for what happens if the bequest exceeded 12 shares, how vague terms like heirs equally should be interpreted, rules for how last shares were distributed.
It sounds almost mathematical.
It was very systematic, trying to foresee and regulate every contingency to ensure clarity and order in property transmission.
And what about damages? The lexically, you mentioned it was purely objective.
Ruthlessly so.
Yeah.
It focused solely on the objective market value of the damaged property. Personal feelings, sentimental value. Irrelevant.
That example of the son.
Yes, the source says even if it's your own son who was killed unlawfully and you'd pay anything to ransom him, the law under lex equilia only cares about his market value, treated essentially as property. It's a cold economic calculation of loss, hugely different from the Athenian emphasis on appealing to the jury's sympathy and sense of outrage.
Okay, incredibly different approaches. Let's bring it home. Section 4. Enduring legacies. In final contrast, what's the lasting gift of Athens?
I think Athens really gave us the foundational political ideal of self-governing justice. This is rooted in their concepts of autonomia, the right of a community to use its own laws and courts. Yes. And eleutheria, freedom. This wasn't just navel-gazing. It was a sophisticated idea developed to manage relations between city-states. It's the ancestor of our modern idea of political sovereignty and self-determination.
But there was a potential downside to this focus on the collective, the polis, something about individual conscience.
Well, the sources suggest that this intense focus on the state and civic participation might have, perhaps, hindered the development of a strong sense of individual moral or religious consciousness separate from the demands of the state or family.
How so?
Unlike, say, the Jewish tradition, which strongly emphasized individual moral accountability to God, both Athenian and Roman systems tended to locate morality primarily within the civic sphere. Duty was to the state, to the family, to the gods of the city. Religion in Rome, for example, didn't really make a strong appeal to the individual's inner sense of right and wrong. It was about correct ritual and maintaining civic order. So accountability remained largely external,
Right.
civic.
And that very autonomy Athens championed, the independence of the polis, was ultimately fragile.
Tragically so. That quote from Aeschines, after Alexander the Great had basically conquered Greece, lamenting how all the great affairs of Hellas suddenly seemed of small account. It's poignant. It shows how vulnerable these independent city-state legal systems were to being swept away by larger geopolitical forces.
A sobering reminder. Okay, so Rome's legacy, it feels much more direct in terms of actual law.
It is, in many ways. The Roman legacy is that systematic legal science. The methods and doctrines developed by the jurists formed the bedrock of huge parts of modern law, especially civil law traditions.
Specific examples.
Contract law principles, like the formal requirements of stipulatio,
Right.
rules for transferring property, like mancipatio, and their incredibly detailed definitions of things like theft, furto.
Right, the pledge, using the pledged item, or the slave stealing herself.
Exactly. That level of technical analysis defining rights and obligations with such precision, that's a direct Roman inheritance. They built a massive body of universally applicable rules, the Aetins Gentium.
But we come back to the unequal application. Universal rules, but applied differently based on status.
Yes, that crucial distinction between the honestiores, the upper classes, and the humiliores, the lower classes, especially in criminal law. It's the big asterisk next to Roman legal universalism.
And the punishments really drove that home.
Drastically different.
Mhm.
For the same crime, an honestiores might face exile or loss of status. Humiliores could face the mines, crucifixion, being thrown from the Tarpeian rock. It was a system designed to maintain social hierarchy through punishment. The legal science was sophisticated, but the justice delivered was profoundly unequal.
So bringing it all together in our final thoughts, the big contrast seems clear.
I think so. Athens gives us the political vision, justice by the people, for the people, deeply tied to democratic freedom and participation.
While Rome gives us the methodology, the professional expertise, the systematic analysis, the legal science that allows for complex societies.
So asking which was better is probably the wrong question. They were each perfectly suited, or perhaps perfectly reflective of their own societies.
Rome's legacy is maybe more visible in the black letter of the law today.
In specific doctrines, yes. The structure of contracts, property, obligations in many systems owes a huge debt to Roman jurists. Their methods, interpretation, fictions, systematic organization are still influential.
But Athens' ideals, democratic control, the public trial, justice as a civic virtue, those still shape our political aspirations for law, even if professionals run the system day to day.
Absolutely. They represent two different vital strands woven into our legal DNA.
Okay, a final provocative thought to leave our listeners with.
Well, think about this. Despite their differences, our sources show that in both systems, political power ultimately held sway. In Athens, the assembly could disregard legal niceties for political ends. In Rome, imperial authority and social hierarchy deeply shaped the application of justice. Aeschines saw Hellenic law become of small account when the political landscape shifted drastically.
So the question is,
To what extent can any legal system ever be truly independent from the political power structure that underpins it and ultimately wields it? Is law always, in the final analysis, downstream from politics?
that tension between the ideal of impartial law and the reality of political power. Definitely something to chew on. A deep dive for another time, perhaps. Thank you so much for this comparison.
My pleasure. It's a endlessly fascinating contrast.
And thank you all for joining us on the deep dive.